comprehensive history of one of the most fundamental rights here, the revised and expanded edition of Alexander Keyssar's The Right to Vote, The Contested History of Democracy in the United States. This is a topic and a book that is directly related to the work that we do here in the democracy program at Demos to reduce barriers to voting, particularly for groups that have been historically disfranchised. Alexander Keyssar is the Matthew W. Sterling Jr. Professor of History and Social Policy at the Harvard Kennedy School of Government. Alex specializes in issues that have contemporary policy implications, such as election reform, the history of democracies, and the history of poverty. In addition to being an indispensable resource to everyone in the field, Alex's book, The Right to Vote, has won numerous awards, including being named the best book in U.S. history by both the American Historical Association and the Historical Society. It was also a finalist for the Pulitzer Prize and for the Los Angeles Times Book Award. The original edition of the book was published prior to the 2000 election. As you may have heard, a few things have happened since then in the area of election and voting rights, not the least of which was the 2000 election debacle and the renewed focus on voting rights in elections that it spurred. In 2000, Alex published a revised and expanded edition of the book, which featured some expansions of the earlier material, as well as an additional chapter on everything that's been going on in the past 10 years or so. The Right to Vote the book is a challenge to the conventional narrative that the history of voting rights has been a sort of continuous and inevitable march forward in which barriers to the franchise are dismantled one by one. In its place, Alex paints a much more nuanced picture of the expansions and contractions of the franchise that have occurred throughout history, often aligned with major social, political, and economic changes. So it should come as no surprise that this past decade as well has also been characterized by advances and setbacks in the area of voting rights. Here to join Alex in the discussion of his book and what has happened since are two leading experts in the area. Debo Adegbile is the Director of Litigation at the NAACP Legal Defense and Education Fund. Debo recently successfully argued against the constitutional challenge to the core provisions of one of the core provisions of the Voting Rights Act before the Supreme Court in the Nimino case, something which I'm sure he'll talk more about in his comments. Tova Andrea Wang is Senior Democracy Fellow here at Demos and a Democracy Fellow at the Century Foundation. Tova was the executive director of the Century Foundation's post-2004 election reform working group, and in 2001 served as a staff person for the National Commission on Federal Election Reform, which was the blue ribbon commission charged with addressing what happened in the 2000 election that was co-chaired by former presidents Carter and Ford. Finally, two topics that I'm sure will come up today are voting rights for individuals with felony convictions as well as redistricting. Demos, along with the Public Policy and Education Fund of New York, the Brennan Center, the Public Policy, the Prison Policy Initiative, and a whole host of other groups are currently involved in a campaign to change the way the New York legislature uses census data to count prisoners for the purpose of drawing its legislative districts. State currently counts prisoners not in the community of their legal residence, that being where they're from and ultimately returned to, but rather the districts in which they are imprisoned. The result is a transfer of political power largely away from the large urban communities comprised largely of people of color to mostly rural and suburban communities. We think this practice undermines the core goal of fair representation. There are postcards that are on both the little tables in the back that we encourage everyone to fill out. Basically, they will go to New York Citizen Action, which is one of our partners in this effort, and they will compile them and deliver them to the legislature. So those are out there if you want to just fill one out. There's also a basket next to them. If you want to leave it there, we'll actually take care of mailing it in for you. So with that, I'll turn it over to Alex.
Can you hear me even if I... No? Ah, okay. Let me finish knocking down the furniture here. Thank you, Scott, and I want to thank Demos and all the other co-sponsors of this event for making this event possible, and especially Tova Wang, whose brainchild this was, and Ginny Candela, who helped to organize it. And this is just a pleasure for me to have a chance to talk about these issues. I'm going to talk a little bit about the book, and to also share some thoughts with Tova and Debo, two people whom I've known for quite a while and whose work I greatly admire. I think the place that I should start is that when the original edition of The Right to Vote was published in September of 2000, just before the election, I was accused at the time of having written the best timed academic history that anyone had ever done. The 2000 election served as a large publicity stunt for my book. When I wrote that book, and when I was finishing that book, it never would have occurred to me that I would have 10 years later prepared a second edition. That was only partly because I was exhausted, and the thought of writing another word seemed daunting, not to mention another book. But it was also because I thought that I had told a story that had a beginning, a middle, and something of an end. I thought that I had sort of written about this 2 centuries of the history, and that it had rounded out. There had been an opening at the nation's birth, very prolonged periods of struggle with ups and downs, but that there was something of an ending to the story in the second half of the 20th century, that voting rights, that it looked like a number of the basic issues had been settled. There had been an enormous transformation of voting rights in the 1960s, or the long 1960s, from the late 50s into the early 70s. One can reasonably talk about the United States as having something approximating universal suffrage by 1970. I mean, that's a little later than Congressional Quarterly would tell us we got universal suffrage, but so the story did seem to have an ending, and I was not naive. I was aware that there were a number of very major loose ends, but after all, Strom Thurmond had voted for the Voting Rights Act in 1982. Indicating something had changed in the United States. The Motor Voter Bill had been passed in the early 1990s. It did seem that we were in a period where we had widely accepted democratic norms and something close to universal suffrage. And then, of course, came the 2000 election, which put an intense spotlight on our electoral systems at a moment of great stress. And it revealed that our democratic norms could be overwhelmed by partisanship, and that the institutions that we had, the laws and institutions to protect the right to vote, were more than a little shaky. I mean, I think some part of what happened in 2000 was that it revealed that the metaphor that I've come to use is that what we have is a kind of strange patchwork quilt of laws and protections for voting rights. And from a distance, it can look fairly solid, but if you shine a spotlight on it, and what you see is there's actually a lot of holes in it. Parts of it are frayed at the edges. There are pieces that don't quite fit together very well. This all evolved over a period of 2 centuries, and what it looked like was that the holes, the frayed edges, were leaving plenty of room for conflict and for abuse. Just to refer, to some of the things that came up in 2000, it was very clear that our electoral systems, meaning not just the technology, but actually the administration and organization of elections, were not adequate for determining in a reasonably secure way what the outcome was of a close election. I mean, that's a flaw in an election system. It also became clear that our election systems were subject to partisan manipulation. If you remember the legendary Katherine Harris, a graduate of the Kennedy School of Government, I must confess, but before my time. And we also learned in 2000 that, and this is a subject which we will be talking about more, that our laws governing the disfranchisement of felons and ex-felons could have a grave impact on elections. And they were also an extraordinary example, not the only example, but an extraordinary example of variations from one state to another in this patchwork quilt, so that millions, part of the story which became so clear was that millions of people who could vote in one state could not vote if they happened to live in other states. And this is in a national election, you know, and in a country which sees itself as an entire nation. In the end, that's kind of weird. We also learned that with the focus being attached to the Electoral College once again, that not all votes count equally. If you live in South Dakota, you have much more political power than if you live in New York. And at the end of the whole episode, in the Supreme Court decision in Bush v. Gore, we learned that actually we don't really have a right to vote anyway, unless our state legislature decides that we do, and decides not to reverse that decision. I mean, I felt that was like the final insult to the whole 2000 episode. It was, ha ha, you don't have a right to vote anyway. But you know, moving beyond 2000 election, I think that what was most striking in retrospect about the 2000 election was that it did not turn out to be an exception. And this is what Scott referred to before. It did not turn out to be a blip, a kind of perfect storm of the super close election in a state like Florida with its particular laws, its particular configuration of political and social forces. I think at some level, we all, there may be sort of wise exceptions out there. I can confess that I thought that probably this was going to turn out to be a sensational event, but then things would return to some kind of normalcy, whatever that meant. But instead, what happened was that the 2000 election inaugurated what has now become a full decade in which voting rights have once again been a major issue on the political agenda, leading to reforms, rollbacks, and a great deal of contestation and conflict. And I think that's a lot of what we're going to be talking about. Just to allude to a couple of different things, obviously we witnessed the passage of the Help America Vote Act, which is sometimes called the Leave No Voter Behind, but which did do certain kinds of things. It did make certain positive changes, but it also created new arenas of conflict. And we were talking, some of us last week, I mean, there's now the idea that coming out of the 2000 election, sort of requiring provisional ballots seemed like a really good idea, but now we have this debate in different states and different locales of when, under what circumstances you actually have to count the provisional ballots. There's also a whole post-election saga around technology, which is actually, it's a quite compelling story, I think, about a very American impulse to find a technological solution to a complex political and social problem. And you may recall that the technological solution that everybody rushed to, which was DRE machines, the electronic machines, then became the solution that everybody tried to rush away from. And so it's a rather startling story in a certain way, but it has its own logic. We also see during the same period the renewal of the Voting Rights Act, but it's certainly not clear that that signaled a durable settlement or really signaled acceptance of the principles and goals of the Voting Rights Act, since, as we all know, a court challenge was filed to the reauthorization of the Voting Rights Act about, I don't know, it was about 20 minutes after it was passed. And the Supreme Court now has clearly indicated, or at least a lot of members of the Supreme Court have clearly given some indication they regard Section 5 as vulnerable. On felon disfranchisement laws, a very interesting pattern over the last decade where the laws have been liberalized in a lot of states, and significant progress has been made. That's the good news. The bad news is that the number of people with felony convictions has increased dramatically, so that the number of people actually disfranchised because of felony convictions has gone up. Despite the liberalization of the laws. There's also been the battle over photo ID requirements, which, and again, most people in this room sort of know something about that, but it's the passage of laws to solve a problem that does not exist, the problem of in-person voter impersonation fraud. but which will have the effect of keeping from the ballot some relatively small but noticeable percentage of people who don't have driver's licenses, in effect. And then there's been endless combat during this period over charges of fraud, of electoral fraud and voter suppression, which it's really been quite. I actually did a little one advantage of computer technology. I did a search on the phrase voter suppression, and you almost never find it anywhere in print before the 1990s. And the use of it goes up absolutely dramatically after the 2000 election. I mean, it's become part of our common lexicon, but this was actually a term that was very rarely used much before 2000. And those conflicts over voter fraud and voter suppression, over those issues really spilled into fairly major areas. I mean, that was what was underneath the U.S. attorney scandal, which we fondly remember. That was also what was going on in the great Acorn kerfluffle. You may remember in the third presidential debate that Senator McCain said that perhaps one of the greatest electoral frauds in American history was underway. Fortunately, he did add perhaps, since there was really very little to it. I mean, in effect, a lot of history happened between 2000 and 2008, and that, I think, when I think about what led me to write the new edition of the book, which was published in the summer of 2009, it's really because so much happened, and because what happened also seemed to articulate with and do something of a reprise of a number of the major issues that surfaced throughout U.S. history with regard to the right to vote. And let me just mention a couple of those and then make some brief concluding comments. One is the notion that, and Scott mentioned, I mean, that the book that I wrote was offering, at the time, a counter-interpretation of the evolution of voting rights and of democracy in the United States, going against the dominant story. And I was arguing that these rights were always contested and conflicted. I mean, this is now, since it was a correct interpretation, I think it's now widely accepted, at least by the people in this room. But one certainly sees this continuing. One sees continuing a conflict between people who regard voting as a right and people who regard it as a privilege. Now, it's relatively rare that people are going to come out and say, I think voting is a privilege, not a right. But I think, anyone who's been involved, I have heard people say this. I've heard people who are involved in the elections and political business say this. So that what you have is an ongoing story of conflict and contestation, in what changes is not the fundamental impulses, some of which are profoundly anti-democratic. What changes is the arena and locus of conflict. The specific things over which are fought. I mean, in the late 20th century, it looked like districting had become the place where conflict was happening, but now it has turned back in some arenas to the right to vote itself. A second theme was that the decentralized piecework institutions that evolved over history encourage conflict over voting rights in a variety of decentralized ways, and that's not an accident. To some degree, the decentralization of voting rights laws and the evolution of American democracy was instituted and maintained in order to let particular states and particular regions exclude the people of their choice, and to exclude sort of minorities and the poor of particular descriptions, which might vary from one part of the country to another. A third and quite disturbing notion, which shows up earlier in the history and shows up in this period as well, is the fact that voting rights can be rolled back. The story is not a story of continuous advance. A little-known episode that happened right at the beginning of the last decade in my home state of Massachusetts, although actually it was finalized just before I moved there, but incarcerated prisoners could vote in Massachusetts until 2000. Okay, it was one of the 3 states where people who were incarcerated could vote. Then actually in 1999, a prisoners' rights group was formed trying to get better conditions for prisoners And they even suggested they were going to form a political action committee to mobilize in elections. That turned out to be a serious strategic error, and the response of the then Republican governor was to initiate a constitutional amendment to bar incarcerated prisoners from voting. You speak out, you get uppity, we will show you, and they did. And so felons who could vote in Massachusetts for 200 years lost the right to vote. You may also recall that another group that lost the right to vote thanks to photo ID laws seems to be nuns in Indiana, who used to be able to vote, but especially elderly nuns who don't have driver's licenses. These kinds of things are happening, and they will continue to happen. People lose the right to vote. I mean, it's something that I think we really have to impress upon ourselves. And finally, the last thing to say about these themes is that social class remains critical to the story about voting rights and democracy. Obviously, it intersects in powerful ways with race and ethnicity in the United States. It does and it always has. But the fundamental issue is whether the relatively poor and relatively unempowered can gain some leverage in American society through the political system. And that still looks more insecure than, again, than I would hope, and I think people in this room would hope. Let me conclude here with a couple of minutes of speculation as I think about what a historian, I think it was a historian's question about the events of the last decade and what's going on, which is to ask, and admittedly prematurely, it's too early to really ask this, but to ask, why has the last decade, starting in 2000, seemed to have been filled with so much conflict and contestation? Why the ongoing skirmishing over elections and electoral power in a nation that does officially and formally adhere to democratic norms, and a nation that believes it has embraced democracy and universal suffrage for 2 centuries? I mean, why, kind of what has been going on? I think part of the answer does reside in the 2000 elections in two respects. One was that there was a lot of partisan acrimony came out of that election. There was just a lot of bitterness, a lot of anger, very understandably. And the 2000 election also demonstrated that every vote really does count. Really close elections, just sort of increase the importance to political managers of making sure either you turn your own people out or that the other side doesn't. I mean, any political manager, any campaign manager will tell you that keeping the other people's folks from voting, it does just as much good as getting your own people to the polls. I mean, and they all know that. And this is part of the story of the last decade, I think, is that this has been a period of real partisan balance. Quite like the late 19th century. I mean, this last decade reminds me a whole lot of the final decades of the late 19th century in several different respects. But I also think it's the case that there are broader currents, broader tensions in American society and American politics that are playing a role here. I don't think that the conflicts, what various people like David Iglesias, the former U.S. Attorney in New Mexico, described somebody like Karl Rove as obsessed with the issue of voter fraud and obsessed with trying to limit people at the polls. I don't think that this is just coming out of things going on within the electoral arena itself. I think that we turned the corner in 2000 and obviously in 2001. We turned the corner into a period where it appears that control of the federal government is more important than ever, and I think that really is. I mean, if you remember back, into the distant past, the era of 1999 of peace, prosperity, and budget surpluses. Okay, I mean, you know, this may seem like a hallucination, but that was actually the circumstances that we had in 1999 or 2000. It didn't seem like it made so much difference who held office, which party held office. I mean, the reason so many people voted for Ralph Nader, I mean, was partly they didn't like Gore, but it was also because they thought it probably didn't matter so much. I think there is a sense now that it matters very deeply in terms of foreign policy, that we are feeling threatened and anxious about that. In terms of the political economy, it certainly does seem to matter. I mean, what is going on in many ways in domestic policy is a fight over income and wealth distribution. It's not called that, but people playing in Washington and playing in politics around know that that's what this is about. And there is no longer confidence, I think, as there was briefly again in the 90s and as there was in the 60s. And I think that this was part of the reason that we could get changes in voting rights in the 60s. There was enough confidence in growth so that people felt that you could basically you could give to everyone without sacrificing, both in the economy and in political rights. And that was present again in the 90s, and I think that that is absolutely gone now. And finally, I think the other thing that we're seeing that's exacerbating the tensions and raising the temperature of political conflict is immigration. We are in a period of quite high immigration, again, as was true in the late 19th century. I mean, there's a real parallel. In the late 19th century, you have high immigration and, for a period, African-American empowerment in the South. And we have some version of that again today. And there is a reaction against it. There are reactions, the social tensions around that. I happen to be at a meeting in Congress, I think it was in, Deborah, correct me on the date, but I think it was like in June of 2006. It was right at the point where the reauthorization got stalled a little bit because of a revolt in Congress. I mean, the deals have been all cut, and I happened to be there at some meetings, in Congress, and a lot of what that was about, where people were really concerned about non-English speakers. And they were sort of, and I was talking to several members of Congress, who said, kind of saying that part of what they were fighting against was this slightly hallucinatory image that undocumented immigrant workers were pouring across the border from Mexico, and we're going to go vote in their states. I mean, which was the last thing in the world they had in mind. But there is tension, there is anxiety about that, and so I guess part of what I'm saying is that the United States really feels like it's in quite a different place in 2010 and even 2006, 2007 than it did a decade earlier. And I think it's part of that broad fabric, the broad changes that are contributing to the increased levels of conflict over voting. And I apologize for going on a little long, but
notably, I think that it's important not to have any conversation about voting be narrowed to judicial interpretations, because at the end of the day, the Constitution calls for a conversation between multiple institutional actors in the area of voting. The Reconstruction Amendments were designed and expressly give Congress a role to play in enforcing voting rights that had only been an aspiration and not really practiced for over 100 years after the 15th Amendment was passed. And it was not until the Civil Rights era and the Voting Rights Act was passed that many people got to participate in the electorate in any meaningful way. Part of the difficulty and part of what allowed 100 years of disfranchisement to occur after the Civil War was interpretations of the Reconstruction Amendments from the Supreme Court. That is to say, they played an active role in undermining the equality principles that were in the Constitution. So, as a lawyer, I respect the court. I occasionally have to appear there and try and try and convey the utmost respect to the panel that I'm before, but as an advocate and as somebody that reads the Constitution, I know that the court is not always the end of the story, and I think that's a good thing and an important thing in our democracy. I also want to pick up on a couple of themes, one of which Alex set the table for, and another of which I think I'll throw into the soup. The first theme is this idea between voting being a privilege versus a right, and I want to talk a little bit about what that means in a practical sense, right? Because it's an important thing to think about, but what does that mean in a practical sense? If voting is a privilege, what it means is that officials can put barriers in your way before you can exercise it, right? It means that all types of obstacles and obstacle courses can be put between the voters and their exercise of the franchise. And we've seen that play out in the United States over many generations. It didn't stop with poll taxes or literacy tests. There are things that are less expressly racially tinged or discriminatory that can nonetheless constrict the electorate and are designed to do so. They are designed to limit the number of people who can participate and vote on election day. So this concept of voting being a privilege versus a right, if it's a right, it's yours to claim and to exercise. If it's a privilege, it allows people to set up barriers, and we've seen those barriers set throughout the history of the country, and Alex's book goes through many of them. So I think it's a very important read. The other issue that I want to put on the table, though, comes directly from our history, and that is to say that we have made a substantial amount of progress along certain dimensions in terms of inclusion in the political process. As a civil rights lawyer and a lawyer at the NAACP Legal Defense Fund, I'm very familiar with the history that my predecessors helped create of fighting for voting rights at the time of extreme exclusion for African Americans in the Deep South and many other parts of the country. It's noteworthy that African Americans were not the only folks that were banned from voting categorically, and that there were many folks in Texas, Latinos in Texas, and Native Americans in other parts of the country who experienced some of the same types of disfranchisement that we read about in the history books in the southern United States prior to the Civil Rights Movement. But the important progress that I think we need to acknowledge in this area presents a separate challenge. And it, in part, is tied to this earlier theme of privilege versus right. There are those who want to use the progress that we have achieved to announce the final chapter to the story. That is to say, because we have made progress, we no longer have a duty to be vigilant and to continue to expand the franchise, protect the franchise, and guard against retrenchment, which is one of the themes that I think Alex's book covers so well. And this idea about what to do with the progress we've made and what it means for the political conversation and the idea of the broad sharing of the franchise is a very important one. The Voting Rights Act story, in part, you can sort of trace the arc of the Civil Rights Movement, of the progress of this concept of privilege versus right through the story of the Voting Rights Act. The Voting Rights Act, as many, if not all of you know, was passed after a period of extreme exclusion, and it was a confluence of a number of different factors. In the last presidential election, I think the Democratic candidates for president got in a little spat over how it was that the Voting Rights Act came to be. Was it the power of a talented president who had been a master legislator? Was it LBJ? Was it the citizens who mobilized on the ground in Alabama and elsewhere? Was it the people that brought the Voting Rights Act? And I think I have the historian here, so he can perhaps have the last say. But my own view is that both pieces played a role. That the Voting Rights Act would not have happened without people putting themselves in harm's way, as John Lewis, who literally put himself in harm's way on the Edmund Pettus Bridge in 1965, is fond of saying. I don't think it would have happened if it was left to the politicians, and I don't think it could have happened if politicians didn't step up to do the right thing and enforce the Constitution. So I see it as a confluence of events. In 2006, I had the opportunity to work with Alex and many other folks to work on the reauthorization of an important part of the Voting Rights Act. There is a piece of the Voting Rights Act that is designed to root out discrimination in some of the parts of the country where that discrimination has been has taken deepest root. Many of these parts of the country are in the southern United States, but not exclusively in the southern United States. And the particular provision that I was working to help Congress reauthorize was a provision which is called the federal preclearance provision. What this law does is it requires elected officials and folks that run elections to come forward and demonstrate that any time they change the rules for voting, that those rules don't have a discriminatory impact on minority populations. It was designed in that way because the pattern of discriminatory voting rules was so constant and so troubling under our Constitution that a case-by-case approach proved to be completely inadequate to vindicate the principles of the Constitution. And when this act was passed in 1965, the federal preclearance provision, as part of the Voting Rights Act, it was determined by Congress that it should only apply for a certain period of time, the idea being that we would be past these problems fairly quickly. So it was originally passed for 5 years, but Congress has had to come back periodically, measure progress to date, and decide whether or not the protections are still necessary. In 2006 was the last time that Congress had this examination. And what they found was that there had been tremendous progress. There had been hosts of minority elected officials in many of the covered jurisdictions. Voters were voting and registered in much higher numbers than they had been, certainly in '65 and the years that followed. But they also found that there was another part of the story, which was persisting efforts to narrow the franchise in some of these parts of the country. And so Congress, as they sat, was trying to decide what to do with the progress on one hand and the continuing evidence of ongoing problems. And they decided to reauthorize the act, which brought the constitutional challenge of which Alex spoke. In that case, which I had an opportunity to participate in, we were faced with these issues. It was very interesting to see that the case came to the Supreme Court after Barack Obama was elected, and so that put a fine point on this question of progress. After the nation had elected the first African-American president, there were many people who were asking, is there any connection left to those days of civil rights, of the civil rights movement, of the march on the Edmund Pettus Bridge, or have we overcome? Are we done? And many people were prepared to ask that question. It was interesting to see that in the litigation, it was one of the themes that the small jurisdiction in Texas who brought this challenge, it was a small water district, a governmental entity out of Texas that had almost no burden imposed on it by this federal preclearance provision. They had, in 25 years, only had about 8 occasions when they needed to have voting changes submitted to the federal government at all, and yet they brought this case urging that they were being oppressed in some way by the act and that the Supreme Court should declare it unconstitutional or at least remove them from the requirement of having to submit their voting changes for approval. What was staggering about it is that the proponents of this litigation really tried to seize onto the Obama moment and almost push to one side the 15,000 pages of the congressional record, the multiple examples of continuing discrimination that Congress examined. Congress found that there had been more voting discrimination that had been stopped under the act between 1982 and 2006 than there had been between 1965 and 1982. And so there really was a story that had 2 pieces to it. And the Supreme Court, when we got there, was prepared to sort of approach these questions almost from first principles. They didn't seem to be terribly concerned with the 5 precedents or 4 precedents of the Supreme Court that had upheld this part of the Voting Rights Act. They were more focused on the political question about how much progress had been made and whether or not these jurisdictions should be covered in any way by this important provision. And we tried to turn the court's attention back to the record and to Congress's role in expounding the record and to having a role in the constitutional conversation. At the end of the day, the Supreme Court decided not to hold the act unconstitutional. Although, as Alex pointed out, they did thunder at us during the oral argument. They thundered in the written opinion about the concerns that they had with the act. But they found a smaller statutory way to let the jurisdiction escape from coverage under this provision of the act, and the result is, in a sense, a victory for the civil rights community because the act remains intact. And there are jurisdictions being protected in all or part of 16 states because Section 5 is still in place. Now, this challenge was part of a whole series of cases that have come before the court. Alex mentioned some other areas, and I'll touch briefly upon them. There was a there's been a whole host of felon disfranchisement litigation. The trend line in the federal courts is that is not a positive one in the area of felon disfranchisement litigation. The courts have not been willing to strike down felon disfranchisement laws, notwithstanding their very substantial impact in altering the electorate. It's noteworthy to sort of think about how the felon disfranchisement laws have played out. At the time that most of these laws were passed, the category of felonies was much smaller. As we have expanded the category of felonies, the felon disfranchisement laws act as a trap of sorts that exclude hosts of people from participating in the electorate because our criminal justice system has large disparities along racial lines. They have special distorting effects in minority communities, and most significantly, because the voting is a learned behavior, they have felon disfranchisement laws have intergenerational effects, where you have the non-voting practices, being excluded from the electorate, being passed from one generation to the next. And I think that's a substantial thing to keep an eye on. My colleagues at LDF won a very important case in which a federal appellate court found that Washington State's felon disfranchisement system violates the Voting Rights Act. It's a very recent ruling within the last month. That case, no doubt, will be appealed, and so we've not come to rest on that ruling. But what was noteworthy is that the court commented specifically on the nexus between racial discrimination in the criminal justice system and how it's joining with these felon disfranchisement laws to exclude up to 25% of the black male African American electorate in Washington State. Very substantial numbers, and in that way has distorting effects. Photo ID and litigation in the area of photo ID, I think, is a very important piece of this contested history of democracy, right? It comes back to the idea of putting barriers in the way. There are those who are concerned about the way in which the electorate may be changing, and I think that it's noteworthy that that concern is being manifested by these impediments to the franchise, whether or not there's any justification for them. The idea that there can be more barriers put in the way itself has value, and so we've seen laws across many states, and perhaps Tova will touch upon it a little bit, trying to put new barriers in the way, and photo ID is a great one. Many people in this room, and perhaps watching elsewhere, may think that photo ID is not a serious impediment. I have a driver's license in my pocket. Many of you sitting here or listening probably have some type of identification in your pocket. But I would call for you to think about a different piece of America. I want to take you back for a moment to some of the folks that were stranded on roofs in New Orleans, Louisiana, after the floods, where America sort of was awoken to an underclass that doesn't have access to all of the things that many of us might, and to think about what the marginal costs of obtaining a piece of identification to participate in voting might be for families that already do not have enough wealth to be able to have food all the way to the end of the month. The nexus of these things are important, and what photo ID does, viewed through that lens, is it changes and takes away the opportunity to mobilize along class lines, as Alex suggested. And so we shouldn't be so quick to think because we have photo ID, it's not an impediment. If you view voting as a privilege, everybody has it regardless of your economic status. And if you put barriers in the way of poor people, again, there will be disparities along racial lines. You're doing something that, in my view, is at violence with a conception of broad democracy. I'll close so that my colleagues can get in here and we can save some time for a thoroughgoing conversation. But I want to mention two things, one about progress and one about where I'm leaving here to go. First, the piece about progress. An interesting thing in the litigation in the Voting Rights Act case was that 6 states filed a brief urging that the Supreme Court not strike down or uphold the federal preclearance provision. Two of those states were Louisiana and Mississippi. I think that this is a very important marker that two of the states who had been notorious in disfranchising large numbers of African Americans in 2006 said that the Voting Rights Act has been an agent of change that has helped us confront our history and our ongoing problems, and that we don't want you, Supreme Court, to strike down this act should tell us something about the role of the Voting Rights Act and the continuing work that it's doing. It's a lever there that allows itself to be a democracy checkpoint. It helps us check to make sure that the democracy is healthy. And if Louisiana and Mississippi, who, by the way, I note, still had a lot of problems in the congressional record, if they are prepared to claim it and note the ongoing work, I don't think that 5 justices of the Supreme Court should turn us back to an uglier time in our history. And finally, on a related note, I'm leaving here to travel to Alabama. This weekend is the 45th anniversary of the Bloody Sunday March, the march on the Edmund Pettus Bridge in Selma. My colleagues are on their way down there now, and so there will be additional convenings where we will talk about these issues, reflect on the progress that has been made, but hopefully gird ourselves for the fights that are yet to come. I'm delighted to be here with you and look forward to the discussion.
Hi, thanks to all of you for coming, and I also really want to thank Alex and Debo, who are both sort of heroes of mine, so it's a real honor to be working with them. One of the things that Alex talks about a lot in the book, and also with respect to this most recent period, is that there have been different eras, different periods of contestation in American history over voting rights and access to the ballot. And that one of the themes is that the arena for the battles has shifted at different periods of time. And perhaps it's due to the type of work that I do that I have a particular bias, but I really see 2000 to 2010 as an era in which the battlegrounds was in the states. That was where our new era of contestation really had its locus. That it was a period of partisan fighting among state legislators with the help of partisanly elected secretaries of state and other election administrators to manipulate, misinterpret, and otherwise, sort of abuse election laws and policies in order to disenfranchise people who they'd rather not have voting for political reasons. And this has resulted in an enormous amount of litigation, which is, one of the also battlegrounds of contestation, but often at the state level, not in the federal courts, although it has often been appealed to the federal courts. That voting rights advocates primarily have had to undertake. And unfortunately, these efforts of the state legislatures, with the assistance of some of these partisanly election administrators, have mostly won out, I think, during this decade. And as has been true throughout American history, as Alex details, these efforts have been primarily directed at poor minorities and immigrants, which has been true in other periods of our democracy and is certainly, in my opinion, the case now. What I think set the stage for this, unfortunately, and for some of us inadvertently, was the passage of the Help America Vote Act in 2002. HAVA, as it's commonly known as, was, as most legislation is, at least in this era, the result of compromise. And the fundamental compromise was that there were going to be certain requirements put on the states. But what HAVA also did, and that was the good part, and those of us who are involved in it, who are voting rights people, that's what we wanted, mandates, not any kind of like conditional funding attached to something to try and goad states to do it with the right thing. But they left open to the states to interpret how basically to implement those mandates. And so in a way, it was a great setup because you have these mandates, but they gave the states so much discretion in how they went about implementing them that rather than being a solid step in the march towards expanding access to the ballot, which there was a lot of hope HAVA would do, it became a tool for partisan election players, for political actors to use to actually disenfranchise people in large measure. And the way in which we have this incredibly disenfranchised system of voting in this country remain very much intact. Before I get too far down the road of negativity, maybe it's also for my mental health, like Deva said, I want to talk about some of the positive developments that have occurred in the last 10 years before I talk about what I see as the defining character of this era, which is partisan manipulation of election laws for partisan purposes. One area that we've been talking about a lot, actually, let me start with one thing. I want to talk about what Harvard did that was good, that I still think was good. For the first time in our history, as Alex talks about, the federal government stepped up and gave money for the purposes of implementing elections. The federal government had never given a dime towards our election system before the Help America Vote Act, and they did ante up $3.8 billion, although in terms of future funding, that's very unclear. Another thing that gets really forgotten about, especially in the whole fighting over the DRE machines and the paper trails, is the fact that one thing that Harvard required that was really important was that it insisted that voting machines be accessible to the disabled and for language minorities. And I think that was really huge and has been largely forgotten about. And that machines also have to notify people of overvotes, which was also, I think, a major improvement, ended up being very important and something that gets forgotten about. The other thing is that has been trending positive has been implementation of the NVRA, the Motor Voter Bill. Most people know it as the Motor Voter Bill as being the bill that allows you to register to vote when you're at the Department of Motor Vehicles or by mail. But also there's another provision in the NVRA that talks about that you have to have voter registration services at public assistance agencies. And that was meant to balance out the Department of Motor Vehicles because there was a realization at that time that many poor people would not be going to DMVs, but they would be going to public assistance agencies. For many, many years that have been left completely unenforced in many areas or very under-enforced. And organizations like Demos and a lot of our colleagues got involved in trying to prod the states into implementing these laws and filed litigation where necessary. And so as a result, you have in several states a huge increase in the number of people registering to vote through public assistance agencies, where we've had to negotiate out something or where we've filed litigation, and we're talking huge percentage increases in some places like North Carolina and Ohio and Missouri. And the other good news is, some people have been frustrated with certain aspects of the Obama administration and its inability to move forward on certain issues. I think one thing we'd agree on since 2008 is that the Department of Justice actually has changed quite a bit with the Obama administration coming in and replacing the Bush administration DOJ. And so one thing that's been good to see is that it appears as if the DOJ now is taking enforcement of this provision of the MVRA quite seriously, and so there's a much better working relationship on that. Another good thing has been the slow, but still an increase in the number of states that are doing same-day registration. The last 3 states, the newest states, are Montana, North Carolina, and Iowa, and you have seen great increases in turnout, especially in North Carolina and those states. And same-day registration is being considered all over the country, and it's hugely important. It's the one thing we know in terms of like an election administration fix that demonstrably improves voter turnout. And also, we go back to felon reenfranchisement. I feel like it is one area in which at least the trend is positive. You have a number of states, and Alex talks about this in the new chapter in his book, that have liberalized their felon disenfranchisement laws, more than a dozen actually, and other places have made it easier to regain voting rights after having committed a felony. So I feel like that's an area in which at least it's trending positive. So let me talk for a minute about how the Help America Vote Act ended up being manipulated for the worse at the state level. David talked a little bit about ID. I feel like, and Alex will have to correct me if I'm wrong in the history of this, but Hava sort of set the stage, planted the seed for this explosion sort of at the state level of voter ID bills. There was a lot of back and forth during the negotiations over Hava about ID. And what they came up with was a very limited ID requirement for a very limited set of people. But it also said that this did not mean that states couldn't make their voting ID laws more restrictive. And states just seem to have run with that. And you have a number of states now that have enacted laws that are far more strict than the federal requirement. And as Debo was talking about, especially in places like Indiana and Georgia that require government-issued photo ID, it just threatens to and has disenfranchised the usual people who are, excluded from the system, the poor, minorities, immigrants, young people, actually also people with disabilities, and so on. And unfortunately, the march towards this barrier to voting continues unabated. There are a number of state legislatures this year that are actively considering and are on their way towards passing very restrictive ID laws that we're now having to contend with. And I think this has probably been the biggest, most controversial and partisan battleground of them all. I mean, there have been some really extreme partisan fights over ID in the states. And this has also bled into requiring proof of citizenship in order to register to vote. Arizona actually passed by referendum Proposition 200 a couple of years ago that now requires documentary evidence of citizenship in order to register to vote. And this was clearly aimed at immigrant voters, naturalized citizens. It was part of Prop 200 was a larger measure that addressed many areas of immigrant access to benefits. And an interesting part of the law was that every kind of documentary evidence of citizenship could be photocopied and mailed in, except for naturalization papers, which had to be presented in their original in person. Just recently, last year, actually, Georgia passed a law that mimics this law almost exactly, and they have now decided that rather than submit it to DOJ for pre-clearance, as Debo was talking about, because they know that DOJ is likely to, object to it, they're going straight, most likely, to the federal court, district court, to get a declaratory judgment on it. And I'm afraid that this may actually lead to the next round in the battle over the Voting Rights Act, and we may see Debo back there in the Supreme Court once again, trying to keep intact this incredibly vital piece of law. And just to talk a second about statewide computerized databases, seemed like a great idea, could be a great idea, but again, you had partisan election administrators and elections officials using the databases to disenfranchise people. Worst kind of instance was in Florida just this past time around, where you had the election official insisting that when you registered to vote, every single thing on your voter registration form had to exactly match what was in the statewide database. Otherwise, your application was kicked out. And you had thousands of people who had their registrations tossed out because of this. And as usual, it was overwhelmingly Latino and African American voters who are subjected to this. And also just, the whole voter registration system still hasn't gotten any better in the last 10 years. There's been a lot of talk about it, but, back in 2000, there was the famous MIT Caltech voting technology project report that showed that, around 3 to 5 million people were disenfranchised because of problems with voter registration. And just last year, Stephen Ansel-Bahir he's from MIT, did a study again, and they found practically the same number. Alex talked a little bit about provisional ballots, another area of huge partisan dispute in the states, litigation, thousands of people being disenfranchised because of states that allow everyone to vote, I guess, because they're allowed to vote by provisional ballot, even if they're not on the registration list, which we all thought was going to be a grand improvement because no one would be turned away from the polls, until they decided that, well, if you were in the wrong precinct and you cast a ballot, your vote would be completely tossed out. Even if, if people are from New York, I know that, when I was voting here, there'd be like a big gymnasium or church or something, and you'd have a different precinct, at each table. So basically, if you went to the wrong table, or more likely were told to go to the wrong table, and you cast a ballot, be completely excluded. And I just sort of want to end up with the continuation of the kinds of vote suppression techniques that we have seen for a long time throughout our history that continue unabated. One of them being challenges to people's eligibility, both to be on the registration list and also challengers confronting people at the polls. This has been going on forever, but especially since the 1950s, blatantly directed at African Americans and Latino voters. It was a huge problem in 2004, if people remember, huge amount of litigation, thousands and thousands of people affected. It's actually estimated that about 500,000 people in 2004 were in some way looked into as to whether they were eligible or not by outside groups. Just a couple of years ago, it emerged that there were, 43 pages of emails from the Bush, Cheney, and RNC demonstrating that they had these kind of caging and challenge programs ready to go in New Mexico, Ohio, Florida, Nevada, and Pennsylvania. And there's been no attempt at the state level to change these laws, pretty much. It's not even discussed. There was a bill introduced in Congress to deal with it, but it's gone nowhere. And then you have the issue of deceptive practices, which is sort of the new way of, voter intimidation in some ways, where you have posters go up in African American communities telling people all sorts of misinformation about the voting process meant to intimidate and mislead them. And one of the interesting things now is how that has moved online. So that now in this last election cycle, you saw emails going around saying, Democrats vote on Wednesday and Republicans vote on Tuesday. It used to be that you could only carry that message as far as you could distribute flyers and post them in, African American neighborhoods, but now it's, you can affect millions of people through the internet. So I have to say, I think overall at the state level, I think the state battles have resulted in voting rights being diminished during this period. I think it's been highly dependent on the partisan makeup of state legislatures and elections officials, which I think is really unfortunate and is another issue that we need to address, especially in terms of having partisan election administration. And I don't really see it going in a positive direction right now, except in the areas in which I identified already as trending in a good direction. And I agree very much that this debate will be very closely tied to the debate over immigration in this country. I think the two issues will, in many instances, succeed and fail together. And that's it. So we'll turn it to Scott to facilitate conversation.
Great. Thank you all. I'm just going to throw out one question briefly, and then we can start taking some questions from the audience. So to shift from history to the next 10 years, the 2010 census is coming up in less than a month. Preparatory efforts have been underway for over a year now to ensure the most accurate count possible. Census data, of course, is used in the redistricting process at the state and federal level. One of the biggest stories expected to come out of this round of redistricting is the increase in Latino residents and their corresponding increase in political power. There's a study by America's Voice that found that there are several states that are expected to increase the number of seats due to the increase in their Latino populations. I would just be interested in getting your takes, whether it's from a historical perspective or in terms of what we can expect in the courts or in the states, as to what you see coming out of the 2010 census and this round of redistricting.
Good.
Well, one of the things that we have to think about in terms of our embrace of democracy is that democracy is an embrace of risk. It's an embrace of a risk that you will lose and be in the minority. And there are some who are not terribly comfortable with the embrace of that risk. Everybody's favorite candidate loses sometimes. And so when there are these large transitions, and when there are new groups that are making demands for political power, certainly the history under the Voting Rights Act has been that it's at that point that there's some type of pushback or some type of effort to diminish the power that this new group may exercise in the political process. So I think that the census will show, of course, that there are more Latinos in the United States. Many of them are eligible voters, and some of the entrenched powers are going to be made uneasy by that fact. I think that some of the currents of making voting harder are trying to get ahead of the inevitable transformation of the country. And so there will be friction, and it will play out in a variety of communities. I think that's guaranteed, just as guaranteed as the change in the numbers is.
Just shockingly, I have a historical response to this, which is, I think that what political professionals are bracing for, and I think that what's out there is a really the potential for a significant partisan realignment. Maybe I'll use this one. one thing that's often forgotten, the change in partisan politics that took place in the United States in the 1930s was not simply a product of FDR's magic and the Great Depression. The main thing that happened there was the coming of voting age and voting legality. The highest rate of naturalization in U.S. history took place between 1928 and 1936. And the other thing that happened was the children of the waves of immigrants, who had come between 1900 and 1917, became of voting age in the 1930s. Something similar is about to happen in the United States with immigrants, and it can produce an enormous political shift, and one that I think that contemporary pundits who are all agog about the Tea Party are not picking up. But I think that I think there's a lot of apprehension and anxiety about this potential shift.
We can move to the audience, I think.
So we can take some questions now. I just ask that you just state your name.
My name is Jeff Weiss, and I'm a counsel in the New York Legislature, and I teach election law at Hofstra Law School. I have a question to Debo, who I've also litigated with, so just a little caveat there. Taking the question further on immigration and citizenship, there's a new challenge to the Voting Rights Act out of Texas, bringing citizenship into the equation. If you can comment on where you think that might go as a threat in the use of citizenship and these new immigration numbers in the future, in the next round of redistricting, which obviously will have a major impact in all 50 states.
Sure. As I understand the Texas case, I think it's framed as an equal protection violation, a one person, one vote challenge under the Constitution. The idea being that the only people that should count are citizens for purposes of apportionment. There are constitutional rules about trying to make districts equipopulous, have roughly the same number of folks, so that people's votes don't have added influence in a legislature, so that everybody can sort of be equal. And I really don't know where these cases are going to go. I know that they will keep coming because it is, Alex said that what happens is that the battle sort of migrates to a new area. And so I think that is in anticipation of the census, which is followed by redistricting. If you will, the partisans are starting their engines already to get ready to try and reframe the rules about who gets counted and how the lines are drawn. So, I've learned enough not to handicap where litigation is going, but I think that it's part of this discomfort with allowing everybody to have a voice in our electorate, and we just have to see where it goes.
The gentleman in back.
Tom DeLuca, Fordham University. What you're all describing in a way is a kind of legal trench warfare that's going on now and will continue to go on. I was wondering if there's a more political, more holistic kind of approach in the sense of, for example, a national campaign to achieve something like automatic voter registration, or to make election days a true holiday throughout the country, something that could be done by the Congress that would have some impact, turning up voter turnout in ways that would at least mitigate some of the effects of all of these micro efforts to stop voter turnout in a variety of ways.
I mean, there are groups and organizations working to do that, and they've been working on this for quite some time. But they start, Tova and I were talking earlier about how do you talk about this story without sounding partisan. The fact
Which I
is,
did a great job of.
But you do start bumping the places that have tried to do this legislatively. The fact is that most Republicans do not want to increase turnout. Okay, it's that they do. In fact, they'd like to decrease turnout. So then unless there is significant Democratic control of all branches of a legislature, I guess we have a Democratic Congress now, but we've noticed there's a few problems there. It's proven remarkably difficult to duplicate. I mean, but I agree with you. I mean, I think the route, I mean, I would rather see this all happen through a kind of political mobilization rather than in the courts, but it's been tough.
Let me just pick up on that also. I mean, I talk about the partisan battles, and I think it's really, really unfortunate because I'm not really clear on how it came to be, and this is something I'm struggling with, this book I'm trying to write that Alex has been mentoring me on, is how it evolved that the concept of voting as a privilege has become, or a right, has become an ideological issue. Because I feel, even in my own work sometimes, as though because I do firmly believe that voting is a right, that is somehow seen as partisan. And I find that difficult to grapple with. And I think that we do see that in the Congress. You know, I don't really think that anything is going to major is going to happen in the Congress anytime soon. I know that we and groups like Wendy from the Brennan Center is here have worked on, you know, exactly what you're talking about, voter registration modernization that would tackle a lot of these problems in one, you know, big, you know, effort. But, you know, I increasingly during this era of, you know, extreme partisanship, believe that in some ways we need to continue to focus on the states where you can, in some instances, have some victories in terms of increasing access to the ballot. I mean, one thing that I was going to mention was that, you know, whereas I think the federal courts, particularly the Supreme Court, is, you know, not a pretty picture right now, especially in light of Citizens United, which really demonstrated, you know, some startling views on democracy. That there may be more success to be had in terms of vindicating voting rights in state courts because it is so difficult to get anything done, it seems, at the federal level.
Hi there, my name is Judy Komaki, and I was very interested in your comment, Alex, about the fact that there has been quite a bit of conflict about voting rights since 2000, and in particular you mentioned about immigration. And several of the panelists also talked about the need to have some kind of documentation to identify that you are in fact a U.S. citizen and all the problems that go along with that. My question is, what alternative is there? I mean, is there a better alternative given that some of the use of photo ID has been problematic that perhaps some states have implemented? Because the issue of identifying whether or not you are indeed a citizen still remains. And so it's not a problem that's going to go away.
My own view about this, and it applies a little bit to ID requirements in general, and this is not a view that is unanimous. People who do voting rights, in fact, it's probably a minority view, is that I have no real objection to having ID requirements or even having a citizenship requirement, you know, something, if it becomes a part of formal public policy that everybody has. Never mind. That everybody has. That we create a system of national identification cards. Okay, I mean, this is what civilized countries do. You know, that people, everybody has an ID card, and that ID card could identify various things about you, and it could indicate your citizenship. You know, again, this is the most common practice, but it would be the responsibility of, you know, in effect, of the national state, of the government, to make sure that everybody has such a thing, not make it the responsibility of the individual to go schlepping 35 or 50 miles to go find one. And if, you know, and what part of what's interesting about the current political battle is that a lot of the same people who are insisting that you have an ID are absolutely opposed to the idea of creating a national mandatory system of IDs.
Yeah, I mean, you know, my views on this are known, that I'm, you know, very much against strict voter identification requirements. But, you know, I can see in an ideal world, if the federal government actually went through the process of spending the resources necessary and the political capital necessary and everything else to actually make sure that every single person had this ID card, no matter, you know, what their place in life, location geographically, everyone had it, then I would be open to a conversation about requiring it in order to vote. But that's not going to happen. And so then to leave us with a system in which people have to come up with all sorts of documentation that they may truly not be able to obtain and certainly not have on hand. I don't know how many people here just happen to have their birth certificates lying around their houses. I don't. That's not a tenable situation.
The only thing I would add briefly is that to the extent that there would ever be a national ID, which some groups oppose for a variety of reasons, but to the extent that there ever would be a national ID, I wonder if the proponents would then be open to election day registration, right? That is to say, today we're having an election, we know who you are, you can prove who you are, why don't you come up and vote, right? It would be interesting to see if the people who are putting these barriers in the way would then have a more robust notion of democracy if their fear of having improper voters participate is taken away. And I'm prepared to say to you that I suspect the answer to that question would be no.
I also want to make sure to note that, as it is now, in order to register to vote, you have to swear or affirm that you are a citizen of the United States under penalty of criminal law. And that, if you are a non-citizen and you register to vote, you are subject to deportation and imprisonment. And so the idea that people who are not citizens are running out to sign up to vote and voting, especially given the current climate, it seems far-fetched to me. And so again, you're talking about trying to address a problem that is largely, a figment of people's fears and imagination.
My name is Morris Kramer. I was the plaintiff in a Supreme Court case, Kramer versus Union Free District, which was the last one-man, one-vote from the Warren Court. Just a quick comment. We had a form of mail national ID way back when we had a draft, because we didn't carry around a draft card. At least we stopped you could be arrested. So so we can have a national ID if we really work it out correctly. One of the things with my case was it opened up the voting rights for people who didn't live in certain areas, didn't have certain income involvement and so forth. And it spread the vote in a lot of states to a lot of people at colleges, a lot of students at colleges. And I think a 1989 court ruling, affirmed the right to vote at colleges where students reside. However, college presidents do not, and they're mandated to mail registration forms to all incoming students or all students at the beginning of the year. They should be having voting registration on campus, from the college itself, and they're not doing it. And this is a state hearing by Senator Jeff Klein from New York State, and it shows you things like 90% did not mail voter registration forms to students. And one of the things they want to do is that basically college presidents are trying to keep things quiet. They don't want to upset elected officials, so they really don't want to encourage the students to vote. So they put an obstacle in the way. And my question is, how can we just really blow this up and make the college presidents act or get out of the way? Thank you.
Well, I haven't given careful study to these particular statistics, but it seems to me that if there was ever a population who could be reached through electronic means, notwithstanding what voter registration drives administrators at colleges are doing, it would be college students, young people that by and large, not in every case, but by and large are plugged into the internet and to opportunities to be reached that way. So I think that student organizations and other League of Women Voters, other folks that do mobilization of voters have been doing some mobilization on college campuses, but it could certainly increase. And I think the changes in the electronic mediums provide a new opportunity. One footnote: some of the evidence that was before Congress, before the reauthorization of the Voting Rights Act, were specific efforts to diminish the voting rights of African American students at traditionally black universities in Texas, and this was not ancient history. This was stuff that was happening post-2000. So it's interesting that some of these efforts regenerate themselves over time.
Yeah, I mean, we didn't talk about it, but obstacles to student voting is actually a pretty major issue, and comes up every election cycle too. And mostly, it's the product of election administrators, inadvertently or otherwise, completely misinforming students about their right to vote from the address in which they're at school, and telling them that if they do so, that they're jeopardizing all sorts of things, and their parents' taxes, and their ability to get financial aid. So that's a huge problem, and one of the things that I would certainly advocate for is, clarification, if not the national level, at least by each Secretary of State or the state legislatures, to clarify that students do, in fact, under Supreme Court ruling, have the right to vote from where they live at school. So I think that would be, one step in the direction. And just, again, with the whole movement towards voter registration modernization, one of the components of that would be to have students who go to public universities, at least, have anyone who registers to vote, who registers for school, would be automatically registered to vote and put into the voter registration database unless they told the school that they did not want to. And so, and that's when we call on Wendy, maybe she can talk more about that from the Brennan Center, but that certainly is part of the concept.
Here in front.
I personally would like clarification on student voting. I know that for the census, if a student is away from home, at a school away from home, they are registered as a resident at the school. But it's always been unclear, do college students have a choice as to whether they will vote at home? I've also heard kids say, gee, we can vote twice, which is very upsetting.
That's clearly not right.
I mean, it's not right.
And really doesn't, that's another kind of myth out there that happens a lot. No, I mean, yes, students have a choice. They can either, they can choose where they consider their, residence to be. They can choose to, they can decide that it is where they live at school, or they can decide that it is back, where they lived at home. And, there was a Supreme Court case about that some years ago that laid that out, but there's still tremendous confusion over it, different state laws on the subject that further muddy the waters, and it certainly is not followed that way by election administrators and sometimes, politicians.
My name is Marjorie Shea, and I've worked with the League of Women Voters and also Women's City Club here in New York. And Debo, I wanted to ask you about pre-clearance, and in that Texas case, the bailout provisions. In New York City, if you live in Queens or Staten Island, you're not subject, the laws aren't subject to pre-clearance. The other three counties, you are. And so, isn't that a strange situation? If I live in Queens, I have to report to DOJ when I want to change a poll site. But if I live in Manhattan, you do have to. And it seems to me, wouldn't it make sense you either bring in the other two counties or you bail out the three counties that are subject to pre-clearance?
It's a very good question. It's a question that was, in effect, on the mind of somebody by the name of Anthony Kennedy, who tends to be important in cases that go to the Supreme Court on civil rights issues. Fair enough, but I think that the idea is, I think I mentioned that all or part of 16 states are covered by Section 5 of the Voting Rights Act. So here is a permutation on a local level. It means that some places have the requirement of having their voting changes approved by the federal government before they can take effect, and some places do not. The places that have to have their voting changes pre-cleared are designated by virtue of a history of voting discrimination that Congress decided to measure in a particular way, and voting turnout or registration during particular elections. And with some minor changes, that has remained fairly consistent for a number of years. The question that Congress was faced with in 2006 was, should they continue with the system as they have articulated it, Or should they change it in some way? In effect, let some jurisdictions out and bring in some jurisdictions. And for a variety of reasons, they decided to keep it as they had it for a long time, and that was one of the things that the Supreme Court was concerned with. Why are some jurisdictions covered and other jurisdictions are not covered? But here's the constitutional issue. The Supreme Court has ruled a number of times that it's permissible for some jurisdictions to be covered and some jurisdictions not to be covered based on a history of discrimination. The congressional record showed that there was continuing discrimination in many, if not all, of these places, but in many of these places, and for political reasons, Congress decided, in effect, to stay the course with the remedy that's been in place and proven effective and not to adjust it. Could they adjust it? Yes. Should they adjust it? Perhaps. But does the Constitution require them to adjust it when there's evidence of continuing discrimination in places where it has operated for a long time? I think the answer to that question is no, and I think that is what gave the Supreme Court pause. Which body is best situated to decide, the Congress or the court?
Can I just pick up on that to ask both of you a question myself, which is that I wanted to get to, what is the future of the Voting Rights Act? I mean, is Congress going to try and do something preemptively to appease the court and make sure that they don't get rid of it entirely? Are we looking at, in a couple of years, at best, the court going ahead and doing what they seem to indicate they wanted to do in this last case, which is to get rid of it in some form or another? What is your prognostication on this, or what do you think should be done?
I'm only a lawyer, so I'll defer to the historian.
Historians are notoriously bad at the future. Look, I seriously, I was going to defer to Debo, but he probably has to be tactful here.
Yeah, I guess that's the problem.
Because he doesn't want, and I understand that. I guess my view. I think that. The act as it exists now is on shaky grounds and is not going to last very long. It seems to me, in part because of this issue that was, that was discussed. There are contradictions in the current act and in this issue of what is covered and what is not, what areas are covered and what is not covered. One would hope that Congress would in effect try to deal with this in advance, but maybe the strategy in Congress is to wait until there is another case and then respond to another case. But I don't see, my crystal ball tells me that it's not going to endure for very long the way it is. Certainly the legal attacks from the right are going to keep coming, whether there will be a positive resolution to that in the sense of some updated, progressive, supportive legislation is beyond my crystal ball.
I'll just add briefly, it's very difficult to know exactly what's going to happen. One of the things that happened in the case that I participated in is that the Supreme Court made it easier for jurisdictions that are subject to the federal pre-approval process to apply to be exempted from those requirements through the bailout provision that you mentioned. I didn't get all the way down into the weeds, but one feature of the act, since some of you appear to know it at least as well as I do, is that although jurisdictions are covered, if they can demonstrate that for 10 years they have not had voting problems with a number of statutory, there are a number of ways under the act to show that they have a clean bill of health, they can apply to get out from under coverage. That's what this Texas jurisdiction did successfully in this case. And so one way to think about it is that that's an incentive for jurisdictions to comply and not have further problems. And then if they feel some kind of burden from the act, they can apply to be exempted and presumably will be exempted if they can make the showing. And so by doing that, although the court criticized the act, they let some of the strictures of the act, they lessened the strictures of the act, because now it says anybody that's covered can have a clean bill of health for 10 years and then get out. And that, to me, doesn't seem like a terribly onerous burden when what we're dealing with on the other side is depriving minority citizens of the franchise or the equal right to participate in the political process. We have to weigh those things against each other. It's always easy for a court to thunder in dicta, in language that isn't controlling because it's not germane to the issue they're deciding, but it would be a very serious move for the Supreme Court to cast aside the vote of Congress in reauthorizing the Voting Rights Act. The numbers, everybody's sort of counting votes these days in Congress. Let me share with you the vote for the reauthorization of the Voting Rights Act. It was 390 to 33 in the House, and it was 98-0 in the Senate. Again, this goes to the point. It was a contested act in 1965. People thought the Union couldn't survive. But the story has been that the Union could not have survived without the Voting Rights Act. And Congress has internalized that message, and for 5 justices of a starkly divided Supreme Court to try and take that away would be a very somber move.
Getting, a third or half of election officials are getting these wrong. And this is where the average voter is going to get their information. And so my question is, we talk a lot about the higher level, but on the ground implementation, which is, millions of people can't vote because of a felony conviction, and then hundreds of thousands, if not millions more, think they can't vote when they can. And it pertains not just to felony disfranchisement, but questions you might have about on-the-ground implementation.
Former felons, the issue of misinforming or not informing at all former felons about their voting rights, I think, is a huge problem, and it's actually something that we're looking at as well. And part of the problem goes back to what I was talking about earlier about, and what Alex described as this patchwork with holes and phrase, where you have some states that, there are 2 states actually that allow people in prison to vote still, and then you have, 2 states that disenfranchise people for life. And then you have this huge middle ground with all these different rules and all these different things that you have to comply with, and some places where you have to pay fines, and some places where you have to have already served probation and parole, and all sorts of different rules that it would confuse anybody. And we still have, there are still very few states that just do it the simple way, which is to re-enfranchise people upon their fulfillment of in the actual incarceration. And I have often talked